Imagine this. A company, it's going bankrupt, right? On its last legs.
Yeah, tough situation.
But before it finally collapses, the owners, they secretly take company money.
Okay.
And they use it to pay their own personal federal income taxes.
Ah, okay, not good for the company.
Not at all. So the company goes under, bankruptcy trustee comes in, their job, get that money back for the creditors.
Standard procedure, try to recover assets.
But here's the twist. The money went to the government, to the IRS, basically.
Oh.
Can the trustee actually get that money back from Uncle Sam? That's the core question.
Right, that adds a huge complication.
Okay, let's unpack this. Today, we're doing a deep dive into a really interesting Supreme Court case, United States v. Miller. It just came down March 26, 2025.
Very recent, yeah.
Our mission today is to, cut through the legal jargon, get to the heart of this decision.
It's definitely got layers.
We'll look at federal bankruptcy law, how it bumps up against state law, and this whole idea of the government's sovereign immunity.
And what's really fascinating here, I think, is seeing the court balance these two big things.
Which are?
Well, on one hand, you need bankruptcy trustees to be able to recover assets. That's critical for creditors.
Makes sense.
But on the other hand, you have this really old, strong principle of sovereign immunity. The government generally can't be sued without its permission.
So it's a clash.
It is. We'll dig into the arguments, the court's thinking, and sort of the bigger picture of how laws get interpreted.
All right, let's set the scene then. Where does the story start?
It starts with a company called All Resort Group. They were a transportation business based in Utah,
Okay.
and they ran into financial trouble. Around 2013, things weren't looking good.
And that's when the owners started...
Misappropriating funds, yeah, taking company money for personal use.
And here's where it gets really interesting, like you said, for this case. In 2014, specifically,
Right.
these shareholders took about $145,000 of company money
A significant chunk.
and used it to pay their personal federal income tax bills. The company itself got nothing back, zero benefit.
Yeah, that's key. No value returned to the company that actually owned the money.
So fast forward 3 years, 2017,
Predictably, All Resort Group declares bankruptcy.
and a trustee is appointed, David L. Miller. He's the respondent in this Supreme Court case.
Right. His job, as you said, is to recover assets for the creditors. So what does he do?
He sues the United States, tries to claw back those tax payments, get that $145,000 back into the pot for everyone else.
Now, how does he try to do that? What's the legal tool?
He uses a specific part of the Bankruptcy Code, Section 544B.
Okay, Section 544B. What does that let him do?
It basically lets a trustee avoid, undo or cancel transfers that are voidable under applicable law by a creditor who holds an unsecured claim.
Okay, so it's a federal power, but it points somewhere else.
Exactly. It relies on some other law to provide the reason for voiding the transfer.
And in this case, that applicable law was?
Utah's state fraudulent transfer statute. Miller argued that under Utah law, this transfer of company money for personal taxes was fraudulent, so he could use Section 544B to get it back.
Okay, got it. Federal power using a state law reason.
So let's recap the situation. We've got the trustee, Miller. He's using this federal bankruptcy tool, Section 544B,
Right.
which points to Utah's state law about fraudulent transfers.
Yep.
But the money he wants back went to the federal government.
And that's where the immunity shield comes up.
Right. Sovereign immunity. Let's talk about that for a second. What is it, fundamentally?
It's foundational. Simply put, the government, federal or state, can't be sued in court unless it explicitly consents.
It says, okay, you can sue me on this.
Exactly. It's a jurisdictional barrier. It means the court doesn't even have the power or the authority to hear the case against the U.S. unless Congress has passed a law saying immunity is waived for this type of situation.
No waiver, no lawsuit.
Pretty much.
Okay, but isn't there something in the Bankruptcy Code itself about this?
Ah, yes. Good point. Section 106A.
Section 106A, what's that do?
This part of the Bankruptcy Code specifically addresses sovereign immunity. It says quite clearly that the government's sovereign immunity is abrogated, meaning waived or set aside,
Okay.
with respect to a list of, I think it's 59, specific Bankruptcy Code sections.
And is Section 544 the one the trustee used on that list?
It is. Section 544 is right there on the list in 106A.
So it seems like immunity is waived then. Case closed.
Well, that was the big question. That's the legal puzzle the Supreme Court had to solve.
Okay, not that simple.
Not quite. The question was, does that waiver in 106A only apply to the federal claim itself, the Section 544B claim the trustee is bringing? Or does it also waive immunity for the underlying state law claim, the Utah fraudulent transfer statute that's kind of nested inside the federal claim? The state law provides the reason the transfer is bad. Does the waiver cover that reason too?
I see. Does the waiver go all the way down?
Exactly.
Yeah.
That was the core issue.
So what did the government argue? How did they say the waiver didn't apply?
Their argument focused on the actual creditor part of Section 544B. Remember, the trustee steps into the shoes of an actual unsecured creditor.
Right.
The government said, look, outside of bankruptcy, could any actual creditor have sued the federal government under Utah's fraudulent transfer law to get this money back?
And the answer would be?
No, because sovereign immunity would block that state lawsuit against the feds.
Oh, okay.
So the government argued, if no actual creditor could have won that suit outside bankruptcy because of immunity, then the trustee, standing in those same shoes, can't win inside bankruptcy either. The trustee's power under 544B is limited by what the actual creditor could have done.
So the state law claim itself is blocked by immunity, therefore the federal claim that relies on it must fail.
That was their logic. The necessary element of voidable transfer under applicable law by an actual creditor couldn't be met because immunity negates the voidable part against the feds.
Okay. How did the lower courts handle this? You mentioned the trustee one initially.
He did. The bankruptcy court, then the district court, and then the 10th Circuit Court of Appeals, they all sided with Miller, the trustee.
And their thinking was?
They essentially believed that Section 106A's waiver did extend down to the underlying state law claim, that when Congress waived immunity with respect to Section 544, it meant the whole mechanism, including the nested state law basis.
So they read the waiver more broadly.
Yes. But this created a disagreement, a circuit split, because other appellate courts had potentially ruled differently on similar issues.
Which is usually why the Supreme Court steps in.
Exactly, to provide a single nationwide answer.
So the Supreme Court takes the case. What did they decide? Who wrote the opinion?
Justice Jackson delivered the opinion for the majority, and they reversed the 10th Circuit. They sided with the United States.
So the trustee loses in the end?
Correct. The court held that the sovereign immunity waiver in Section 106A applies only to the claim brought under the listed code section, like 544B itself.
But not the underlying state law.
Right. It doesn't automatically waive immunity for the elements or the underlying requirements of that claim, especially when those requirements come from state law.
What was their main reasoning for that distinction? Jurisdictional versus something else?
Exactly. They drew a line between jurisdiction and substance. They said waivers of sovereign immunity are jurisdictional. They let the court hear the case. They open the courthouse door.
Got a ticket in.
Right. But the court stressed these waivers generally do not create new substantive rights or change the actual legal rules you need to satisfy to win the case once you're inside.
So getting in the door doesn't change the rules of the game.
Precisely. The waiver lets the trustee sue the U.S. under 544B, but it doesn't change what the trustee needs to prove under 544B.
And did they point to specific language in the law for this?
They did. They highlighted Section 106A5. It's a specific clause right in the waiver section.
What does it say?
It says, pretty explicitly, nothing in this section, the waiver section, shall create any substantive claim for relief or cause of action not otherwise existing.
Ah, so the waiver itself can't invent a new way to win.
That's how the majority read it. They argued that if reading the waiver broadly meant ignoring the fact that no actual creditor could sue the U.S. under state law because of immunity, then the waiver would effectively be creating a new substantive way for the trustee to win that didn't exist otherwise. And 106A5 forbids that.
Okay, that makes sense. They also talked about the difference between Section 544B and 544A, right?
Yes, that was a key part of their analysis. They emphasized that 544B, the section used here, requires the trustee to step into the shoes of an actual creditor.
We keep coming back to that.
Because it's crucial. Contrast that with Section 544A. That section gives the trustee certain powers to avoid liens, like hypothetical powers, whether or not such a creditor exists.
So 544A doesn't rely on a real-world creditor's rights in the same way.
Exactly. The court said this difference shows Congress made a deliberate choice. For 544B, the trustee's rights are tied directly to and limited by the rights of that actual creditor. If the actual creditor would be blocked by immunity, the trustee is too.
They also mentioned how waivers of immunity should be read, didn't they? Narrowly.
Yes, very important principle. The court reiterated the long-standing rule.
Oh.
Waivers of sovereign immunity must be construed strictly or narrowly.
Meaning?
Meaning, any doubt, any ambiguity in the language of the waiver must be resolved in favor of the government, in favor of not waiving immunity. Congress needs to use unmistakable language if it wants to abrogate immunity.
So no guessing games. It has to be crystal clear.
That's the standard.
What about that phrase with respect to in Section 106A? The lower courts thought that meant the waiver covered everything related to the listed section.
The Supreme Court disagreed on its effect here. They acknowledged the phrase can be broad, but said it's context sensitive.
And in this context?
In the context of a sovereign immunity waiver, which must be read narrowly, and considering Section 106A(5), forbidding creation of substantive rights, they said with respect to, doesn't stretch the waiver to cover the internal elements of the nested state law claim. It just links the waiver to the federal cause of action itself, Section 544B.
Okay. Did they look at the history of the law at all?
They did. They noted that Section 106, historically, has always been seen as a limited waiver. Its goal wasn't to put the government in a worse position in bankruptcy than it would be outside, but to achieve approximately the same result.
Level the playing field, roughly.
Sort of, yeah. And they said even the 1994 amendments, which did expand the waiver in some ways, like allowing monetary judgments against the government, didn't fundamentally change this limited scope regarding the substance of the claims.
Now, one argument might be, if the court's reading is right, does the waiver in 106A even do anything for Section 544B claims against the federal government? Does it become useless?
The court addressed that directly. They said, no, it's not meaningless. It still has work to do.
Like what?
Well, first, it definitely allows trustees to sue and win against the federal government under Section 544A, where you don't need that actual creditor stepping stone for certain things, like avoiding some unrecorded federal tax liens.
Okay, so it works for 544A.
Yes. And second, crucially, the waiver does allow federal courts to hear Section 544B claims against state governments if that state has already waived its own sovereign immunity under its own state laws for fraudulent transfer claims.
Ah, so if the state itself allows such suits, the federal bankruptcy waiver lets the case proceed in federal court.
Exactly. So the waiver isn't a dead letter for 544B. It just doesn't overcome the federal government's immunity on the underlying state law element itself.
Okay, that covers the majority opinion. But there was a dissent, right, Justice Gorsuch?
Yes. Justice Gorsuch wrote a dissent.
What was his main point? He thought the majority got it wrong.
He argued the majority conflates two different things. He fundamentally disagreed with their framing of the issue.
How so?
The dissent's view is like this. Does a valid substantive claim exist under Utah law that a fraudulent transfer occurred? Yes, the dissent says clearly the transfer happened and fits the state law definition. Money improperly left the company.
Okay, so the underlying claim is real.
Right. The question, according to the dissent, isn't whether the claim exists. It's whether the federal government can raise sovereign immunity as an affirmative defense to defeat that otherwise valid claim.
So immunity is a shield, a defense, not something that erases the claim itself.
That's the core of the dissent's argument. They see sovereign immunity as a defense that the government could raise, but that Section 106A explicitly tells the government it cannot raise that specific defense when the claim is brought under Section 544B in bankruptcy court.
So for the dissent, 106A just removes that one specific defense tactic from the government's playbook in this context.
Precisely. It doesn't change the elements the trustee needs to prove about the transfer itself.
Hmm.
Was it fraudulent under Utah law? It just stops the government from saying, you can't sue me because I'm the government, when sued under one of those listed Bankruptcy Code sections.
It doesn't create a new right. It just preserves the trustee's ability to pursue an existing right by disabling a specific defense.
That's the dissenting view, a subtle but really significant difference in perspective on what the waiver achieves.
Wow. Okay, so this deep dive really shows how complex these legal interpretations get, especially where you have these big principles like sovereign immunity bumping up against the practical needs of, cleaning up a bankruptcy.
Absolutely. And the Supreme Court has now drawn a clear line, maybe clearer than before.
What's the main takeaway then?
The court is reinforcing that waivers of sovereign immunity are serious business. If Congress wants the government to be liable for claims that wouldn't fly outside of bankruptcy, it needs to say so very, very clearly. No ambiguity allowed.
Use unmistakable language, as they said.
Right. And connecting this to the bigger picture, you see the court really focusing on the specific text of the statute, reading it quite narrowly when government money is on the line.
It favors protecting the government's immunity unless Congress is incredibly explicit.
That seems to be the strong message. Legislative intent for these waivers has to be expressed directly, not just hinted at or implied. It's definitely a reinforcement of governmental protection in these scenarios.
So this leaves us with something to think about, right? For you, the listener.
Definitely.
How might this ruling actually play out in future bankruptcies? Especially when, say, the IRS might have received payments from a company shortly before it went bankrupt.
Yeah, what does this mean for the strategies trustees might use? Will they have fewer tools to get funds back from the government in these fraudulent transfer situations under 544B?
And will Congress feel the need to react? Maybe amend the law to make the waiver even more explicit if they disagree with this outcome?
It's possible. Or perhaps trustees will focus more on other avoidance powers, like Section 544A, where applicable.
Lots to mull over. We hope this deep dive has given you a clearer picture of what happened in United States v. Miller and